Good day and welcome again to this week's episode of Strictly Legal on WESN Content Capital. I am your host, Rondell Donawa, attorney at law. Once again, I'm happy to be here. Once again, I'm happy to bring the law and you. I know we had a few weeks off, but of course, we are here to recuperate. And as we are in the Christmas season, I want to extend season greetings to your family and yours, and be safe, of course, for the season. Don't spend out all your monies because January has 12 months. Right. Nonetheless, I thank you for being here. You can stream us on WESN-CC as well as our podcast, Strictly Legal with Rondell Donawa. We do have a guest in studio. My resident guest, I shall call him, Mr. Israel Khan, our noble senior counsel, and who's going to speak to us today about the recent judgment that was handed down just last week on senior counsel appointments. And of course, he will speak about it and whether or not there should be time for reform. But before we get into that, we have our legal lingo segment. Let's get into legal lingo. And our legal lingo for today is separation of powers. Separation of powers refers to the constitutional principle that divides the functions of government into three distinct branches: legislative, executive, and judicial, to prevent any one branch from exercising the powers of another. This principle ensures a system of checks and balances where each branch operates independently within its respective domain, but remains accountable to the Constitution and, by extension, the people. And that was separation of powers. And of course, in an example, that is basic public law 101 that first year law students basically read when they're doing jurisprudence. So basically, in our Commonwealth context, this principle often operates within a Westminster system where the separation is not absolute, but tempered by mechanisms such as responsible government. So for example, the executive is drawn from and accountable to the legislature. Judicial independence is preserved through security of tenure and protection from undue influence. So it's important to separate the legislative branch, which is responsible for making laws. Example, the parliament or the legislature. We have the executive branch, that's the branch responsible for implementing and enforcing laws. That is the Prime Minister, the Cabinet, and public administration. And then we have the judicial arm, that's the branch responsible for interpreting laws and adjudicating disputes. For example, the courts. And the separation of power safeguards democratic governance by preventing the concentration of power and protecting individual rights and ensuring the rule of law. So that is separation of powers, our legal lingo, and we'll be right back.
Transform your home with PCU Plus. From stylish furniture to the latest appliances, we have everything you need to create your perfect space. At PCU Plus, we offer fair prices and affordable financing options that are cheaper than hire purchase agreements. With convenient locations in San Fernando, Tobago, Arima, and our lifestyle showroom in Barataria, you're never far from the best deals. Visit PCU Plus today and discover why we're the top choice for quality furniture and appliances. PCU Plus. Quality you trust, prices you'll love. Visit one of our locations or find us online to start transforming your home today.
is your chance to win a bicycle, a ride-on, or a hoverboard. Shop at dbesttoys.com and spend $300 or more to win big.
We've got Barbie,
Hot Wheels, Gel Blasters, Ride-Ons,
Leapfrog,
Nerf, bicycles and tricycles.
Greco, and Wonder Baby.
Visit us in store at Forces Flagship McBean, Movietown, Port of Spain, Eastgate Mall, and M6 Plaza Endeavour. Merry Christmas, everyone!
And welcome back to Strictly Legal. You are watching with Rondell Donawa, attorney at law, as well as our guest, Mr. Israel B. Raja Khan, Senior Counsel. And as I said, our topic for today is Senior Counsel Appointments, Time for Reform. And you know, Mr. Khan, in his wisdom, filed an action for interpretation with respect to the senior counsel appointments. And I don't want to go too much into it because he will be able to explain further. But this claim was filed against the Attorney General of Trinidad and Tobago and an interesting party who would have come on board in this matter, that is the Law Association of Trinidad and Tobago. Now, this judgment was handed down on November 29th, 2024 by the Honorable Mr. Justice Devendra Rampasad. And although it was not successful on Mr. Khan's side, it's important to note in the general ruling certain comments that was made by Justice Rampasad. And I'd just like to read some snippets of this judgment before turning over to senior counsel. Now, particularly in this judgment, of course, as I stated, this is in relation to the senior counsel appointment and whether or not those appointments are constitutional or devoid from political interference. And of course, we will get into how our constitutions were framed and why there is need for reform. But the court notes, and I'm reading verbatim at paragraph 73 of the judgment, that the court notes that the claimant, who is Mr. Khan, over the years has been ardent and persistent in his calls for reform of the current process to ensure that senior counsels are appointed fairly, lawfully and transparently, and he has written several articles which discuss the roles, functions, and the process of the appointment of senior counsels in Trinidad and Tobago, and what needs to be changed about it. Nevertheless, the very fact that the claimant, that's Mr. Khan, has filed these proceedings, even though there is no obvious personal benefit to himself, it indicates the passion and commitment he has towards this very serious issue. And to the extent that he is not willing to just let things lie as they are, but to try to keep the matter going in the forefront of the public domain. And I will pursue paragraph 152, which is equally important. The court commends Mr. Khan for his unwavering commitment to his oath and his role as senior attorney at law in the Republic of Trinidad and Tobago in all sense, and to his deep sense of responsibility and his desire in trying to cultivate and maintain a legal profession which is fiercely independent in the true traditional and the true traditions of counsel. Too many unable or unwilling to walk the walk he has taken. And let's welcome Senior Counsel Israel Khan again to this set. Good morning, Senior.
Good morning, Donawa, and thank you for having me on this program.
And it's always a pleasure you being here. And of course, you know, many students, many luminaries, even the public are always grateful for your advice. And of course, you are one of the fierce senior counsels who will speak out on certain issues that many are afraid to speak out on. And of course, that is commendable. Now, you have recently, I mean, it's not often you will not succeed in a case, right? So this is probably a rare circumstance, right, Senior? This is a rare circumstance. But for the benefit of our viewers as well as our listeners, Can you just give a summary of why, of what this matter is about, and why did you see the need to bring this matter in the public domain, considering there have been a number of years of senior counsel appointments throughout the same method, including yourself, who have been appointed in the same method as people would have argued. But over to you in terms of this matter.
Well, what has happened is that the rank as senior counsel carry a special status in the legal profession, and the lawyers are officers of the court assisting in the administration of justice. And it used to be in England where we inherited this system of appointing Queen's Counsel, King Counsel, and our senior counsel, the Lord Chancellor, who was head of the judiciary, who is also a cabinet minister, both a politician and head of the judiciary, used to make the recommendation to the king and the queen, and then now the king, who should be appointed senior counsel, or working within a senior counsel. So traditionally, is the judiciary making the recommendation. However, since we became independent, our constitution indicated that it must be the prime minister or cabinet that will make a recommendation in relation to the duty and function of the president. Now, Britain has an unwritten constitution. Our constitution is the supreme law of the land. And our constitution states that there shall be a cabinet which will be in charge of the government and they are accountable to the parliament. But our constitution says that the state consists of the president, the executive, and the judiciary. Yeah. That is the state. And this status of senior counsel, Queen's Counsel, is what we refer to as a royal prerogative, which the sovereign power would award to the attorneys. But in our constitution, there's a section saying that the president shall make awards and equivalent of awards and other royal prerogatives on the advice of cabinet, unless there's another law indicating that the president can use her own discretion and make the appointment. Like, for instance, the president must appoint the Chief Justice if a vacancy arises.
And is that on the recommendation of the Prime Minister?
No.
Okay.
What happened, that is in the Constitution, she shall make the, President shall make the appointment.
Yes.
But in the Constitution it states that the President in his own deliberate judgment, after consultation with the Prime Minister and the Leader of the Opposition, shall make that appointment. So it is as clear as the President making that appointment and not a recommendation coming from the Prime Minister or the Leader of the Opposition. Same thing with Service Commission and other important bodies. They say in the Constitution itself, in spite of the fact that the President must act on the advice of Cabinet, there are certain instances where she will exercise her own judgment unless there is something in the Constitution giving her that right or any other law. Now, since we became independent, what happened? Our first Prime Minister, Eric Williams, who was really he wasn't democratic, he was autocratic. He arrogated unto himself that in relation to the appointment of Silk, he will make the recommendation, because it says, in spite of the fact that the judiciary, Lord Chancellor, was making a recommendation, he is saying that under Section 81 of the Constitution, which gives him the right to make recommendation, he will exercise there. He wasn't concerned with any other law. And they follow that system right through. Now, the Law Association other legal luminaries and responsible people in society saying this is not in keeping in interest with the doctrine of separation of powers. And even the present Prime Minister had stated this when Kamla Pusselby-Sissa gave herself silk and other people and so on. It ought not to be that way. It should be an independent body. But he is in power for 9 years and he has not changed that, and he would not change it because the Attorney General in this matter said more or less, and the judge indicated that he is not interested in changing anything. So I took it upon myself to write the association and say this thing must change.
Yeah.
And we should bring a matter in court for interpretation and so on. And the association really didn't take me on. And I filed this writ asking for interpretation. The court ruled, in spite of all the commendation the court heaped upon me, is that it is clearly legal for the Prime Minister to make this recommendation. And it's not unconstitutional, because the court was looking towards the Constitution to see whether there was a section saying in relation to silk, like how they say in relation to the Chief Justice, that the President had this power. Our position was that it's not in the Constitution, not necessarily in the Constitution, it is in some other law which existed, and that is that common law. So before we became independent, it was the judiciary under common law, because they do not have a constitution, recommended to the king to appoint the Queen's Counsel and the King Counsel and the silk. And that is where we are now. But the court gave an ultra conservative judgment, saying the status quo of the President exercising a function must come from the Constitution. And the Constitution says Cabinet will give her the advice in relation to certain things, or unless there's some other law. And that is where we are now.
Now, based on the Attorney General's submissions, they would have responded to your submissions, and basically they would have cited and referred to the Ralvi Balgobin Maraj matter at paragraph 37,
Yes.
Where it was stated, where they stated that the general rule is that in the exercise of his or her functions under the Constitution or any other law, the President must act on the advice of Cabinet.
Yes.
So therefore, it's a matter of interpretation, what the meaning of advice is. And advice is, advice could be guidance, but then if they are saying she must act on the advice of the Cabinet, does that mean that it is absolute?
No,
she cannot return, or she cannot return by
says so, and the Constitution says so. She will act on the advice of the Cabinet unless there is any other law.
Right.
Any other law comes from the common law, and this is what the judge did not really appreciate. He's looking towards the Constitution itself to see whether there was a provision giving her the power, like, for instance, appoint the Chief Justice. He looked towards the Constitution, and Balgobin also did not look at any other law, the common law. And that is before the Privy Council. And soon they will decide whether Balgobin is good law or bad law. You see, the Privy Council will understand this more than our local courts, because they do not have a written constitution. Because what they are saying, you see, our president is not a ceremonial president, you know. Our president has a lot of power, which they have not been exercising at all.
But we've heard that from our former president, Kamuna, who stated that the powers that you think I have, I don't, and the powers you think I don't have, I do.
Yes. And our president could appoint independent senators who ought to be accountable to her. But they have no regard for after they're appointed. They're on their own. There's a lot of things in our Constitution which the president is moving like a figurehead. And the reason for that is the Cabinet and the government of the day, with the majority, selects a president. And if the president wants a second term, they just tag along with the government of the day. So any other law means any other law. It doesn't mean constitutional law alone. It means common law also. And at common law, it is the judiciary that makes the recommendation to the sovereign power to appoint the lawyers. The lawyers are special people, you know. They are officers of the court.
Yeah.
And under the doctrine of separation of powers, is a separate entity. And there's a lot of cases that will come before the court in which lawyers have to assist the court. And they must be independent, totally independent. And the present Prime Minister recognized this when he was a leader of the opposition, but he no longer recognizing it. Because people are very disturbed with certain people who got silk. I am not disturbed with who got silk, though. What I am disturbed with is who did not get. And this is done in secrecy. Even the President Attorney General had said so, but that he was wearing a hat of President of the Law Association.
Right, so it's a matter of convenience, so it's a matter of what office you hold at the time.
Well, they ought not to be that way. The law is the law.
Yeah. No, if I can go back, what is the process for many people who are unaware, or what is the process for appointing silk? What do you have to go through an application stage? Is it a matter of merit where persons are appointed, like for instance in some jurisdiction are appointed by just the fact that they have done numerous matters, they have been successful in the jurisprudence? What is the process in Trinidad and Tobago?
Well, you hit the nail on the head. It's based on your merit, ability, and integrity as an advocate in the courts. So you have to be a trial lawyer. This was only for trial lawyers. But suddenly in Trinidad, they start giving people who maybe have 15 years as operating a bank and they never see a court and a lot of other things, they're giving people silk. Silk was not designed for non-advocates. It had to be how many cases you would have done in court, how many pro bono matters you would have done, how do you assist the society, whether you make a contribution to the criminal justice system or the civil side and so on. It's for advocates. So it is based on merit, ability, and integrity. And who will know the merit and ability and integrity of the advocates? The judges of the country. The Chief Justice heading the Judicial Legal Service Commission with other judges and representatives from the Law Association, ordinary people in society who are non-lawyers. They should have a committee looking at the performance of these people over the years. You just don't give somebody silk because they have been called to the bar for 20, 25 years or no. What you do, you award silk on the basis of the representation in court. But it turned out to be political patronage, as this judge had said. It is causing a lot of really disappointment and criticism of the system.
So is it that there's an ad that is published, and one is invited to apply, and that is basically
yes,
how
the Attorney General will indicate, look, you're going to appoint silk now, and you could make an application. There is a form you fill out. And what you have to say on this form is the complexity of cases you have done, how long have you been operating, and so on, and all these things. It have nothing to do that you have been operating a bank or institution for 20 years, or you have been doing other things other than court. But yet those people got silk.
But the minimum requirement, meaning the minimum years of being an attorney. What is the minimum years?
10 years. 10 years is a benchmark not only for consideration of silk, but for to be appointed to the High Court as a judge. For magistrate, it's 7 years. So they have a period they believe that you could be mature into a senior counsel. So they have 10 years. But most of all, they must indicate the cases you have done in court.
Yeah.
And how you help develop the jurisprudence of the country.
Now you mentioned cases that you would have done in court. Is that our current requirement? Because why I ask that question, there are many persons who have not been conferred senior counsel who do not practice in court. They are solicitors, meaning in state departments,
yes.
And other areas. So is it that that is a requirement, being an advocate now in our jurisprudence?
Yes, in 1965 there was they gazetted the form, and they indicated in the form 10 years call, and also the cases he would have done that developed the jurisprudence was to that effect. And it had nothing to do with people who are not advocates. A solicitor in those days were not advocates, but the profession feels now we are all attorneys of law. The Bar Association made a recommendation. They have two types of silk: those who are advocates and who non-advocates that they would have done other work and so on. So, but I am not concerned with that too much, you know. What I am concerned with is that the Prime Minister of the country is decided who are the leaders of the bar.
And is this by virtue of a committee that is set up by the Constitution? Is it a constitutional committee that is set up to determine or to review these applications?
What happened is the Attorney General could consult this committee and consult other people, but he's not bound to do that.
So he's not bound, so he's not mandated to consult?
No.
But do consultation happen?
Yes, consultation happens by what you think about this person and so on. Consultation does not happen to the person who is not on that list.
Right.
What has happened is that the Prime Minister of the country is really selecting who should be the senior lawyers. But when you put a stamp on a senior lawyer, you know what that means? His consultation fee jumps from $1,000 to $4,000 an hour.
Yeah.
His fee jumped from $30,000 to $100,000. As I say that good lawyers are not cheap and cheap lawyers are not good in Trinidad. And they put them in a category where you could, like the lawyers who are being briefed by the present government and the government to be. The people will be shocked they're making $9 million and $20 million and $40 million of taxpayers' money. I'm not saying they don't vote it, but they are selected. So people think there's political patronage taking place. Whether that happens or not, what I am concerned, my main concern, is that the Prime Minister of the country, and I obtained silk by the recommendation of a Prime Minister now. I went through the same system, but I'm willing to hand back my silk.
No, I was going to raise that question because, and it may be controversial, but I know you can handle it. In that, at the time you were awarded silk, it was in 2011?
2020.
I think it was 10.
No, 2011. 2010.
2010, right.
25 years on.
And that was the time when,
Tajmal Hussein, Carl Hudson
Phillips, 25, what am I saying?
The committee.
Yeah, the committee. But who was the Prime Minister at that time when you were awarded silk?
Basio Pandey. Yeah, he now came into power.
Right.
And I will tell you something about that later on.
Okay, so that would not have been in 2010. That would have been somewhere 19-something. Because I know you were silk, you were awarded silk.
It was just Pandey came into power,
1998, I believe. Yeah, I believe he came into government in 1998. Or the second time, 2001.
Yes. So he was there 2000,
Yeah, 2001.
Yeah.
And some may argue that, well, you were appointed silk by Mr. Pandey, notwithstanding the fact that you are competent, but that it can be politically motivated.
Not politically motivated. It could be also racially motivated.
Okay.
Politically motivated. What has happened when the then Attorney General made a certain recommendation? There was only 2 lawyers from the criminal bar that were recommended, myself and Osborne Charles. Yeah. And the rest came from the civil bar and so on. Prime Minister Pandey included on that list several lawyers who were not advocates. And the then President of the country was hesitant in signing the instrument.
Yep.
And he eventually signed the instrument for everybody. And you know, he never had a ceremony to hand over this instrument. He sent it in a brown envelope to the Attorney General. And the Attorney General is the one who had to call them in and hand them the instrument, including himself, and so on. Because then Robinson was against the Prime Minister exercising this right and selecting non-entities. Just as how people who lost the election came through the Senate and were being made ministers and so on.
And that was challenged.
At that time, yes. So they always had a fight about it. So, and this judge made a point in giving his judgment. There seemed to be political patronage on who you know and who you did not know, etc. But the legal profession, they laugh at some of the lawyers who get silk, quietly.
I mean, I've heard whispers in recent time, yeah. But then that does not solve the fact that they are senior counsel, and they have they have the authority to charge higher fees. So regardless of whether you're laughing at them, whatever the case is, they are still senior counsels.
Yes.
Fortunately or unfortunately for them, and of course that many persons who may have applied have not received silk. For instance, I know that Mr. Nizam Mohammed, I believe, had that.
Yes, he applied. And
he applied and they refused, and there was an issue where he indicated that his name was on the list and then his name was removed. But then how can you challenge that? Because that's by hearsay.
You cannot. Yeah. You cannot challenge it really if they only list and they remove the Prime Minister could scratch off your name.
So you cannot challenge. So one cannot challenge if the appointment or the non-appointment of silk. You cannot challenge the fact that you weren't awarded.
No, you could challenge the process.
The process. But can you file a FOIA in that instance?
Yes, and you could get information whether your name was on the list, whether it was scratched off or whether it was there. And incidentally, when the partnership party came into power, they granted silk to the Chief Justice and a senior judge, Wendell Kangaloo, and Carl Hudson Phillip, together with other senior lawyers, they had an uproar saying that you cannot grant silk to the Chief Justice because that will be giving him a gift as the executive. But in the past, silk had been granted to Prime Minister Robinson himself, to Kamala Persad predecessor herself.
The Prime Minister Robinson
he got silk.
He got silk? Okay.
When he became Prime Minister.
I was very young.
Yes.
I don't even know if I was born.
No. He's also a senior counsel.
Right.
And he hasn't done a...
That was in 1986?
Yes.
Yes.
And he hasn't even done a dog bite case. That a ferocious dog bit somebody. But he got silk.
Right. Yeah, senior. Yes, senior. I mean, you... Sorry, I'm having a moment.
No, but was a good statesman, remember?
Right.
Remember?
Of course.
Remember?
Yes.
He was mainly responsible in advocating and assisting to establish the International Criminal Court,
Agreed, yes.
Maybe he got silk for that. And incidentally, I am a defense counsel on the list. So he got silk for that, but he was not an advocate.
But he did something that was notable within the legal framework.
Yes. Every Prime Minister gets up one morning and says, all right, my wife is a lawyer, I appointed her. My daughter is a lawyer, I appointed her. My son-in-law is a lawyer, I appointed her. Nothing legally could be done unless this case that I filed say, you must not do that.
Yeah. Or it might be, kind of point. This last year of office. We've seen where a lot of, in the political realm, and I'm going off course, for instance, in the United States, and this has nothing to do with this topic, but as you mentioned, Prime Minister, Joe Biden recently pardoned his son.
Yes, that is his prerogative.
Although he said that he will not.
Yes,
But obviously there are probably reasons that we don't know, or maybe obvious as to why he did that, considering...
suspect that the president will lock up his son.
Yeah, lock up his son, or maybe do something that may not be... That may not be politically right.
Yes.
I should say. But back to the instant matter at hand. There's also, there's certain provinces in Canada that has removed the rank of silk. I was just reading where some jurisdictions where the rank of senior counsel was removed, such as example for the provinces of Ontario, Quebec, and Manitoba in Canada. The removal in the named provinces was partly as a result of perceived politicization of the appointments and the fear that it was becoming meaningless.
Well, what they should have done is just remove it from any political input. The last committee of the Law Association, which Daniel was on that committee, and the Attorney General, President Attorney General, my colleague Lennox Sankar Singh was on that committee too. And he gave a dissenting judgment because they said they should restate and so on. And in his dissenting judgment, and his dissenting report, sorry, not judgment, he indicated that silk should be abolished. But they didn't bother with him. But I think we should maintain silk because we ought to know who, they ought to have lawyers who, but you really don't need somebody to tell you you're a good lawyer. This is a small country. Eventually they will know.
Yeah, I agree. And as I say, it's a small country, and it's I mean, there are certain people who I believe deserve, even though they are politicians, they have been, they have passed through the rank and file of the legal fraternity.
Yes.
I mean, in this instance, we've had Stuart Young, SC, who has had a lot of matters before the court. Even the former Attorney General, Faris Al-Rawi, I mean, he did not appoint himself silk at the time when he was AG. He could have done that.
He make a recommendation to the Prime Minister that he be appointed silk because of his work he done in Parliament. But he's not an advocate. He's not an advocate. Stuart Young is an advocate. I do not know about what civil matters he would have done and so on. I only know about criminal laws. Russell Martineau was Attorney General, and nobody could question Russell Martineau's merit, ability, and integrity, in spite of the fact that the present government had briefed him to the tune of $40 million. That is his business. You see, they could make it political, but he's a brilliant lawyer, and his fees are not very high, in relation to other silk. But he does so many cases upon cases, and he must be spending the money just piling up there.
I mean, but one could say that you have also benefited from briefs from the state.
Yes, I benefited from a brief from the state when the PNM was in power. Since the PNM came into power, I haven't gotten a single brief from the government. And without sounding ostentatious, I am the leading criminal lawyer in this country. I don't have to say that a second time for the people to recognize that. When police are charged, and they charge them for, look, the last set of police, 6 police officers. The Attorney General refusing to pay me my professional fees. What I am waiting to see whether the government has changed their requisition again, and if they change, I am going to take him to court. You can ask police officers to go out there and protect, conserve the society. And if they are doing that, they kill somebody.
This is in your recent...
yes, where 6 officers...
Where cost was awarded.
No, this isn't a case where 6 officers in Muruga.
Right, yes, and we did our...
and you refused to pay the fees.
Oh, it has on your fees, your costs.
I will deal with him in another forum, and I'll take him to court beside that. But what I am saying is that why suddenly Israel Khan is not being briefed because a new government is there? Why? Martineau, it does not matter who governs this country, will be briefed. Pasek Pandey is to brief him. Kamla Prasad is to brief him.
I think probably the difference is that probably he doesn't speak out.
He doesn't make any political statements.
Correct. And the society is such that if you make political statements,
he stays in his crease.
In our jurisdiction, because of our small, and even anywhere else in the Caribbean, I should say, because of our small society, it's very hard to make statements and not feel the repercussions of it. But of course, I know that really doesn't affect your pocket because you you are still
what has
someone
happened
who
is
is...
not affect my pocket because for breakfast I will have a piece of sada roti and some tomato choker, and I don't want to make it a big expense. So I was driving a Juke. My lifestyle is not attracted to material things. If it comes, it comes. But I am not going to compromise my principle and my independence. And I will say what I have to say. Kamala Prasad herself, government used to brief me, and when she said that certain lawyers are eat food lawyers, I wrote an open letter to her. I say it is scandalous, it is vulgar, it is insulting, and you yourself cannot talk so about the senior lawyers. Well, hand back your silk, because I do not know a case you have done which you deserve silk. I said that to her, and the country knows that.
What case has she done? Has she done any case?
No.
Okay.
She's not an advocate, but what she has done, she be the Prime Minister.
Prime Minister, okay.
You know, but this lady does not hold any malice against anybody. You know, the same lady convinced some of her people to submit my name for president of the country.
I was going to that point.
Yes.
And maybe because your name was submitted, the present government felt as though it maybe did it disingenuous for them to brief you.
No, I think she admired me in the way I took up a case when she retained me as a private lawyer, the email gate affairs, right?
Okay.
Which turned out to be something else, bogus. And she looked at the lawyers who stand up.
Is it bogus? Because there has been no adjudication on it.
Yes, there had been adjudication. They investigate and investigate and investigate, and there is no such thing. Even a little child would have known those those emails were put together. But that was something else. What I am saying is, the politicians think a certain way.
Okay.
So in spite of that, because I am amazed at this judge who said it is clearly legal, compliment me in the way which he complimented me. You know, the law school honor 7 lawyers, including myself. Out of the...
That's you, thing.
Yes, 50 years existence, these 7 lawyers, including myself, Dana Sital and so on, and the president of CCJ and so on, have contributed to the society and the development of law and so on. So I don't need a silk. I've been teaching at the law school for 37 years, and I like teaching at the law school. I like being here.
There's no doubt that you are one of the best criminal advocates, the best lecturer. You know, you are a mentor, and many attorneys, regardless of whether they want to admit it or not, because maybe they are part of a certain political divide. No one cannot dispute that with you. I mean, every time I have a show that is that features yourself, I get many shares. You know, many shares because people value your input in the legal profession, despite Israel Khan being who he is, being outspoken. And I think it's because you really love your country.
Yeah, but you know what the lawyers quietly say, and other people? Israel Khan is a loose cannon. What that means to say is not going along.
Right, we're not with the status quo.
That is my position.
Correct.
And if among my colleagues that you're doing something which you ought not to do, the cannon I have turn it upon you on fire. But
Senior, you have had, I mean, in your chamber, you have part of your chamber who's now an MP, a government MP.
Yes, Scotland was in my chambers for 10 years. I've been training Peterson, who they just revealed. Well, I won't talk about his fees. I trained him for a short period. We did many cases together. Scotland was in my chambers.
Yes, Scotland was part of your chambers.
Justice Suhan, who became acting Chief Justice, was in my chambers for many years. Many judges passed through my chambers, training them as in service. Right now, I won't call their names, but in the Court of Appeal, they're all over the place, magistrates and so on. What I am concerned with is on this topic is that the Prime Minister shouldn't have an importance in who are the leaders of the bar.
I mean, but in the defense of the Prime Minister, that has been, it is constitutional
Yes, but
Right.
when he was leader of the opposition, he criticized it. He said it ought not to be, and so on. But from the time he became prime minister and he had this power, he's not going to give it up.
Right. And that is, I mean, and that is the reality of many governments, many prime ministers, in that for whatever reason, they believe that, you know, certain powers should remain within their remit to ensure that maybe there's some form of balance. I don't know.
Yes.
It could be a matter of balancing the scale, right, in terms of which society gets silk and balancing the racial divide.
Yes,
of
yes.
persons who are appointed by virtue of their age, ethnicity. I mean, it shouldn't matter. But the reality is that, you know, when certain governments come into power, you know, you see a certain sector.
That I mean to say it right.
Agreed. And at some point, it must be changed. At some point.
And this judge made that point quite clearly, that many legal luminaries, judges, association and so on, have been criticizing the system and leave a sour taste in the profession. And he hoped there will be change. And I had quoted Rowley in my affidavit saying that he said that it ought to change and it shouldn't be left to a political director. The judge referred to all that. This judgment is a serious judgment.
It is. I'm reading it. I've been reading it. And what is notable is where the judge in between paragraph 139 and 142 of his judgment under the heading, the dependence of the criminal bar, dependence of the junior bar, my apologies. Yes. And he stated it is the aspiration of many young attorneys to achieve the rank of senior counsel. Yes. And therefore it is unfair, however, at present for the process to not be transparent and strictly merit-based and determined by persons who work in the field of law and are familiar with the potential senior counsel applicants to be able to properly assess their worthiness of their rank. As it stands, quite often appointments are questioned and ridiculed in the public domain, which is sometimes unfair to the appointee, whose ability may warrant the appointment, but whose affiliations raise questions. On the other hand, questions have been raised about the suitability of appointees, leaving an impression of the dilution of the honor. Yeah, and it is critical to note that, and I want to reiterate, he states that as it stands, quite often appointments are questioned and ridiculed in the public domain, which is sometimes unfair to the appointee, whose ability may warrant the appointment, but whose affiliations raise questions. And it always boils down to who party you support, who prime minister you support, and not based on your merit. And even if you deserve, because of the association, you're ridiculed.
Well, I'm very happy that you quoted that section of the judge's judgment in this matter, because when I became president of the criminal bar, and even before I became president of the criminal bar, as a senior attorney, many people used to complain to me, why they didn't get Silkan, why didn't get Silkan. In judgment, the reference in the judgment that I brought this case on behalf of the lawyers who believed that they deserved Silkan, did not get Silkan, on behalf of the profession, and he complimented me. And I found it, although I'm elated that he recognized that. At the same time, I'm disappointed. He said, well, look, it's constitutional, you go your way. Mm-hmm. But the Balgobin case will be decided soon.
So therefore, it means that if the Balgobin case is decided differently, how will this affect his dicta?
This will show that he got it wrong, that he didn't refer to any other law. Mm-hmm. You see, what people are forgetting.
Yeah.
For 300 years, so-called Great Britain engaged in the African slave trade. And they give royal prerogatives and so on and so on. And they were never saying it illegal, but they passed a law saying it illegal if you involve yourself in slavery when it was no longer profitable to them. In the United States, they brought a case to say the whole is true to be self-evident that all men are created equal. How you could be holding these people as slaves? You know what the court decided? So we must not always look to the court. The court decided that the African slaves were not men, they were chattel. And when they say why they were not men, they say they didn't have a soul. That is in the law books of America. So the courts don't always get it right. So with Balgobin, I'm hoping to say any other law means the common law.
The common law. And if it's the common law, then you may have a case. Now I know the court, basically, in his order, he declared that the requirement of Section 8.1 of the Constitution of Trinidad and Tobago, that the President of the Republic, act in accordance with the advice of Cabinet, or the Minister acting under the general authority of Cabinet, or on the advice of the Honorable Prime Minister in relation to the appointment of attorneys at law at the rank of silk is valid. He also says that he recognizes that the process is valid and accepts that the procedure that applicants for the rank of senior counsel must meet the criteria as to merit and integrity set out in the said Gazette notices. The Attorney General will consult with the Honorable Chief Justice on the applications, and the Attorney General may consult with such other persons or bodies as he considers necessary, but he will be under no obligation to do so. And there are other areas in which he indicated. Now, I mean, I know we don't have much time, but next steps in terms of this judgment, because this was handed down in the High Court.
Yes.
Is there any intentions of appealing this decision?
Certainly, as we speak now, we are preparing the appeal to go to the Court of Appeal.
And on what basis you are appealing?
What we are saying that the judge, learned judge, never consider any other law in relation to the common law, where under the common law is the Lord Chancellor to make the recommendation under the Prime Minister, and under the doctrine of separation of powers, it ought to be the President acting in on our own discretion, and so on. Let me tell you what is wrong with our Constitution also.
Yeah.
The President, when a vacancy would have arose, has the sole discretion in appointing a Chief Justice. But to know if the Chief Justice is misbehaving, as it was alleged that our present Chief Justice was misbehaving, it is the Prime Minister who will decide whether to have a tribunal to find out whether he misbehaving or not. Under 137, and this Prime Minister decided, in spite of all the allegations being made against our Chief Justice, he's not going to advise the President to set up a tribunal. Well, there's a case which was argued just last week, whether the Chief Justice, as the head of the Judicial and Legal Service Commission, forced a judge and coerced a judge to resign. And if the Privy Council find that as a fact, that is misbehavior in public office. You can't kick out somebody as a judge because they had cases sooner and did not do.
Yeah.
Would he trigger 137 to find out again whether that is misbehavior and warrant a removal? He is in control of this Chief Justice.
I think that's a topic for
another topic. That is another topic.
For another discussion. I am grateful that you came here, and I really would like to see the progress of this matter. Whether it is Court of Appeal, I can imagine if the Court of Appeal overturns the lower court's decision, then the state will appeal it to Privy Council, and I'm believing vice versa. So obviously, in determination, it will be the Privy Council, unless at some point in time we subscribe to the CCJ. I'm not sure what is your position on that, but we are out of time.
Well, the CCJ will come. And yes. I must thank you for the way you handle this program. And I know how you handle this program, and you're extremely fair to me, because you're a lawyer, because you're trained as a lawyer, and you bought your learning as a lawyer to look at both sides. Because look, I even omitted to quote what the judge said and so on, and you put it to the public.
Yeah.
The public does not want a Prime Minister really to select the leaders of the bar now. Let them select people who will be member of Parliament and its cabinet if they win and leader the opposition, but not to be member of the bar.
Yeah.
The leaders of the bar. So I'm grateful for this program. Keep it going.
Thank you very much, Sina. It's always I'm always grateful for you being here, and also thanks to the man in the engine room, Daniel, right, who ensures that my guests keeps on coming, I know, on different areas and perspectives of law. So thank you very much, Daniel.
Well, I also hope you enter Parliament just as how Scotland enter Parliament.
That's God's design, but thank you so much, Senior. There you have it, ladies and gentlemen. That was Israel B. Khan. I forgot the name Daniel called you. If it's the street-wise counsel or something like that.
Israel Khan Street.
Israel Khan Street. But thank you so much for joining us. You have been watching Strictly Legal. And before we leave, I leave you with this quote: "Winners never quit, and quitters never win." Vince Lombardi. Yeah. Have a good day. God bless. See you next time.
Thank you.